What a remarkably important article that I implore you all to read in its entirety as soon as this interview is over. Because joining me now are the authors of that article. Judge J. Michael Luttig is a former federal judge on the United States Court of Appeals for the Fourth Circuit. Lawrence Tribe is a professor emeritus at Harvard Law School who taught constitutional law at Harvard for roughly 5 decades. He's the author of the influential treatise, American Constitutional Law. Gentlemen, we are so honored to have you here this morning. Thank you for writing what you've written, because through all the indictments, the January 6th indictment and the Georgia indictment, this is the question that most lay people without a legal education ask me. Is there anything in here that stops Donald Trump, who is shooting to the top of the polls literally every time he's indicted, from becoming the president of the United States again? So I put it to you, Judge Luttig. You have studied this. You have thought about this a lot. You are the man with whom Mike Pence's lawyer consulted before January 6th to make the determination that he was not in a position to overturn the Constitution and count the wrong electoral votes. How have you come to this conclusion?
Thank you, Ali, for having Professor Tribe and I on this morning. Professor Tribe is the most celebrated constitutional mind in America, and he has been that for the past 4 decades at least. Professor Tribe has been studying the Constitution and even the disqualification clause literally his entire illustrious career. I first came to think seriously about the disqualification clause only in January of 2021, after that fateful day of January 6th. But at that time, I came to the same conclusion that Professor Tribe had come to many years before. And Professor Tribe and I have been discussing this profound question between us privately for over the past 2 years. In some ways, one of the most notable things that we say in the Atlantic article this morning is that George Washington, America's very first president, presciently foresaw and anticipated this moment in American history almost 250 years ago in his farewell address. Turning to the merits of what we have explained in this article, constitutional analysis, Ali, as you well know, does not lend itself to sound bites. In this case, though, it does, when coupled with the reading of this article that we've done this morning. And that soundbite is literally that the Constitution in Amendment 14, Section 3, forbids the former president from holding the office of the presidency again because of his conduct in and around January 6, 2021, and specifically in his conduct that either constituted an insurrection against the Constitution of the United States or a rebellion against the Constitution of the United States, or aid and comfort to the insurrection or rebellion that occurred on that fateful day. Under the disqualification clause, the literal terms, the plain meaning, and now we know through the magnificent research of Professors Bald and Paulson, the original meaning of Section 3 disqualifies the former president from ever holding the presidency again, Ali.
And it's not a complicated read. For those Americans who have not had I'm a naturalized American, so when you become a citizen, you get a copy of this, and you can't take your phone into the court. So I read it several times as I became a citizen. It's 30 pages long. Everybody should just read this. Professor Tribe, in the article, you wrote, the former president's efforts to overturn the 2020 presidential election and the resulting attack on the U.S. Capitol place him squarely within the ambit of the disqualification clause, and he is therefore ineligible to serve as president ever again. The most pressing constitutional question facing our country at the moment, then, is whether we will abide by this clear command of the 14th Amendment's disqualification clause, end quote. Tell me how this works, because you read it, you two are constitutional experts, I'm not, but we come to the same conclusion. There are a whole lot of people outside in America who are not coming to this conclusion. So who's the one with the authority to say that Donald Trump or anyone who comes up against this clause is ineligible to run for office under the disqualification clause? In other words, who enforces this?
First of all, Ali, thank you very much for having me on this morning. It's an honor to share the stage with my friend and perhaps the most distinguished judge in America, though he does not at the moment serve on the Supreme Court, where I long ago thought he ought to serve. It's an honor to be here discussing this extraordinarily vital question. Now, you put your finger on it. The Constitution says a lot of things, but it takes people to honor it and to enforce it. Now, some people have made the mistake of thinking that the many charges against the current president represent the forum in which all of this will be decided. The 91 pending criminal charges in 4 separate indictments. But in fact, although those criminal prosecutions are terribly important, and it's vital that the president be held accountable and not get away scot-free, the disqualification clause operates all by itself. All of those prosecutions, important as they are beside the point when it comes to this clause. This clause says that no one who did what Donald J. Trump obviously did, and he doesn't really deny it. He plays games with what we call it, but he doesn't deny. In fact, he proclaims proudly that he thinks the electoral count should have been stopped. He still blames Vice President Pence for not overturning the election. Constitution itself says that he can't be president. Now, who enforces that? Well, in the first instance, it is the officials who decide whether his name can be put in nomination. That is, can he run as an official candidate in Michigan, Wisconsin, Nevada, Georgia, any other state? Usually it is the Secretary of State who must make that call, just as he or she must decide if the president is a natural-born citizen. You remember that Donald Trump said that nobody should allow Barack Obama to run for president because he was disqualified. Trump didn't suggest that we need a lawsuit to settle that. Of course, he was wrong, and therefore secretaries of state did let Barack Obama run. But when any secretary of state decides either to put Donald Trump's name on the ballot for president of the United States in 2024, or to keep his name off the ballot, anyone withstanding to challenge that decision either way, anyone who is harmed by it, a competitor, a voter, will presumably take the Secretary of State to court and say, you did it wrong. This clause of the Constitution doesn't mean what it says. Or it was repealed by the Amnesty Act of 1872. There are all kinds of strange arguments people have made in order to make that clause go away. Or they will say, you should have enforced it. You shouldn't have passed the buck. But whichever way Secretary of State goes, that case will go to court. And because the issue is so momentous, it will end up in the Supreme Court of the United States. Now, that court, even though it has leaned in favor of Donald Trump on a number of occasions, has sometimes done its duty. In all of the cases that reached the court in 2020, the claim that the election was a big lie and that states should be allowed to do what the co-conspirators, most recently charged in Georgia, said that should be done, those people were ultimately turned back by the Supreme Court. I apologize for that fire alarm in the background, but I hope it will not hurt anyone's eardrums. I've pretty much had my say.
If it gets louder, Professor, let us know and we'll let you go and get your fire extinguisher. But for now, we hope everything's okay.
Well, it will turn off. It happened once before. It will turn itself off. But I think it is ringing the alarm bell for all of us, because this is a crucial moment for America.
It is, in fact, a metaphor. Judge, in this very clause that you talk about, the disqualification clause, the last sentence says, but Congress may, by a vote of 2/3 of each house, remove such a disability. Lawrence William Baude and William Stokes Paulson wrote, quote, Section 3 is self-executing, operating as an immediate disqualification from office without the need for additional action by Congress. And the clause itself says that Congress's only role in this clause is to remove it if they think it's not true. That means it's not necessary for Congress to act to disqualify Donald Trump as a presidential candidate. Is that how you read it?
It is, Ali. That specific finding is perhaps the single most important conclusion that was drawn by the professors from their scholarship, namely that, as Professor Tribe said, the clause is automatic. It is self-executing, which means that, as Professor Tribe just explained, anyone, state or federal, who's charged with listing the candidates for the presidency is obligated under the Constitution to make the decision himself or herself as to whether Donald Trump is qualified to be put on the ballot under the Constitution of the United States. As to the role for Congress, frankly, until this scholarship by the two professors, I was not aware of the self-executing feature of Section 3. I'm sure Professor Tribe was. He's thought and written about the disqualification clause his whole life. But this is of momentous significance itself, because neither Congress, nor Congress through impeachment, nor a judicial order, nor the results of a criminal conviction are needed as of this moment under the professor's reading of Section 3 and of my reading and Professor Tribe's. The former president is disqualified from holding the office of the presidency in 2024.
Professor Tribe, on January 7th, I remember having a debate with people about whether this is a coup or an insurrection or whatever the case is. Interestingly enough, none of the charges, none of the indictments discuss insurrection. It's something the January 6th committee wanted done, but it didn't get done. Given that this clause depends on insurrection, does that have to be proved by a court, or do we believe our eyes and the video and the statements and the Truth Social posts? How is that litigated? How do we make the determination that Donald Trump violated this section of the Constitution by fomenting an insurrection?
Well, the answer is that whoever is responsible in the first instance for applying those words must use his or her own eyes and common sense, and the statements made by the president himself when he was president, and everything we know. When you actually strip away all of the rhetoric and all of the slogans of those who say that the president at the time should not be held responsible. They don't deny the facts. They don't deny the facts that he encouraged those people to storm the Capitol when his plots that we now know about in detail to have fake electors and to pressure the vice president when all of them failed. The facts are all really undisputed. The president's responsibility is there for all to see. A lot of people have become obsessed with criminal trials. It's all over television. You're presumed innocent until you're proven guilty. Yes, he's presumed innocent before we can decide otherwise in a court of law and inflict punishment. But that's why the framers of the 14th Amendment took great care not to treat this as a punishment. It's a disability. They call it that. It is not imprisonment. It's not removal from office and impeachment. Because it is not a punishment, because it is not a deprivation of any right or entitlement. Nobody has a right to be president without meeting the qualifications. It has to be applied in the first instance by an ordinary human being who is then challenged in court. What made you think this was an insurrection? The Constitution uses the term insurrection over and over again to make clear what it means. What it means is an organized effort using all means available, up to and including violence if necessary, to prevent the government from performing its functions for the American people. And one of those central functions is the peaceful transfer of power from one president to the next. So I think that any Secretary of State operating without any partisan motive, whether this was Donald Trump or any other president who did it, would have to conclude this was an insurrection, and at a very minimum, he gave it aid and comfort when he decided to let it continue, when he cheered it on, when he pointed a finger of blame at the embattled vice president in the face of the gallows that had been constructed. He gave aid and comfort to the enemies of the Constitution of the United States. And to put a icing on the top of that rather untasty cake, he said, I would terminate the Constitution if necessary, hold on to power. How can he do that and then take an oath to uphold it? Holding his fingers crossed would not suffice. He is not qualified for the presidency.
Most law students would not have the privilege of having this conversation with the two of you, and I appreciate and I'm honored by your time. Judge Luttig, anybody who reads both of those indictments will see your fingerprints all over some of the decisions that were made to uphold the Constitution and not overthrow the last election. So we thank you for your service to the country, and of course, Lawrence, your continued analysis that you have provided the American people and many of our law students with over the last 50 years. We are grateful to both of you. I implore our audience to read the article that has just been published this morning. We will, in fact, I'm going to tweet it out right now so that our audience can read it. Judge J. Michael Luttig is a former federal judge of the U.S. Court of Appeals for the Fourth Circuit. Lawrence Tribe is professor emeritus at Harvard Law School and the author of the book, American Constitutional Law.